differently. I think Rush Limbaugh had the very interesting analysis as he was talking today that what seems so obvious to us about this was utterly shocking to the establishment. The idea that, you mean there could be limits on what Congress does?
Read the Post today.
They were absolutely shocked. I mean, he said, although I am concerned that it may not be a slam dunk as we think it is, it apparently utterly shocked the establishment that there might actually be something Congress can't do.
Were you saying that if the Supreme Court votes for the other side, for the administration, then they are making themselves totally irrelevant in the future? That they will, if they vote for the other side, they will totally lose all the power that they have. So they can't do that. They can't vote in favor of health care because then they will have power over nothing.
Well, I never thought of that. I didn't say that, but it's probably true, because if everything is constitutional, then who needs them anymore?
Right. Yeah.
That's true, at least in their constitutional role.
Well, except that the congressmen of themselves are supposed to pass only that which is constitutional. The Supreme Court is not the ultimate arbiter of constitutional principles. Each of the three branches is compelled to. But I wanted to ask you more specifically about the two cases that I think should give us great confidence. Morrison and Lopez, which were decided, what I want to say almost 10 years ago now, were two cases that did constrain the overreaches of interstate commerce jurisprudence, which, I think it's important to understand that Joe Biden, then Senator Biden, championed this Violence Against Women Act in the Congress. It passed because it was politically favorable, but the U.S. Supreme Court decided that that was an overreach to say that any criminal activity is commerce for the purpose of interstate commerce. As a conservative, I take incredible confidence in those two bits of precedence. What is your position on those? Don't you find those encouraging?
Well, I put together a brief at one point that I hoped we had been able to put together a couple of years ago, and I was making the argument that this is actually compelled. The answer to this case is compelled by Lopez.
Explain to folks what the story was.
I will.
Yep.
Unfortunately, I didn't go back and reread as much about Morrison. But first of all, there has been a desire of conservative justices to try to breathe life back into the 10th Amendment, which is considered dead, and to reassert some limits on the interstate commerce. And so that's one of those cases where they've been biding their time, and even O'Connor and things to see an opportunity to pounce for that. And so Lopez and Morrison were some of those cases where they're looking for an opportunity, were able to get a little bit of those electric paddles back into the dead body, and reassert some limits on Congress. The question is, of course, whether or not by itself it's enough. I think Lopez, if they follow it, is exactly this case, if they frame the question that way. Because Lopez was the gun, I'll get it wrong, thank you, the Gun-Free Zone Control Act, if I'm not mangling it, where, and the issue with Lopez was that merely existing with a gun near a school was a violation. Now, under state law, you can say, well, I don't want people to have a gun near a school, but state governments, of course, are unlimited within constitutional safeguards. So, so a state government, of course, could regulate that. But the United States Supreme Court explicitly analyzed what is commerce, and they explicitly analyzed an active aspect to commerce. That commerce, by its nature, has activity involved in it. They used an old word that we've probably long ignored its original meaning, which they called it intercourse. In the sense that there's activity going on and not just existing. And they said that if you're just sitting there by a school, the mere existence, your mere existence is not commerce. And of course they had to overcome the challenges to the necessary and proper clause and some of these other effect on commerce arguments, and they shot all those down. They said no, it's despite the effect on commerce and everything else, that this is not commerce. So they slapped on a politically popular topic.
Right.
They stood up to Congress and said, you don't have the right, you don't have the power to do this. And again, that was part of what shocked people there, that there might actually be limits. So the question then is whether they're willing to agree. Typically, of course, the Supreme Court and the courts don't like to take huge controversial stands, but I suspect that this has been such a controversy, and not necessarily popular, that I'm not terribly worried about that. I mean, they really don't like to. They like to nibble around the edges and over time change the law. They don't like to stick their neck out and become a real lightning rod, the way they sometimes have, like with Brown versus Board of Education. But I don't think that's going to be a factor this time. It is so controversial, and I don't think they'll have a hesitation on that.
The only way they could is if they picked up Day's one ripeness issue.
You never know.
They picked up what?
The ripeness issue, that the case isn't ripe because no penalty has been exercised against a citizen yet. That's the only way they could punt it.
No, but that was day one, and they got by day one.
No, but the thing is although they had although it's true, day one was the argument, they didn't actually decide necessarily.
Correct.
So I don't think, which is kind of strange. They didn't, they're going to have day one's argument. If they made a decision, would make day two and day three unnecessary. But they went ahead and had the argument anyway, and that's why, if they really don't want to decide, there are all these escape hatches that they can avoid, and the easiest way to get out would be if one more vote wants to say, hey, it's a tax, where if they just want to duck out, they'll duck out, and they can call it a tax, and we
Shame
lose.
on them.
But
Shame
they didn't hesitate 9-0 with the EPA. So that to me is encouraging.
John, you know how they're dancing around, is it a tax, is it a penalty? I don't know if you covered that since I've been in and out of the room, but if it's a tax or a penalty, if it's a tax, then they cannot agree to it, is that correct? Is it the tax, the word tax, they cannot tax this. But the thing is, it is a tax. Basically, it can't be a penalty because the IRS is running the whole thing. You're going to have to report everything about our insurance and everything else about ourselves on our IRS forms. And then the government decides if you have adequate insurance or not. And they can force you to actually buy more insurance if the government, the panels decide you don't have enough or it's not adequate enough.
Right.
And who determines that? Are the new IRS agents, the thousands and thousands that have just been hired to work just healthcare. Now, what does healthcare have to do with the IRS?
But I don't think
That's where the penalty is going to be
issue
collected.
if it's a tax, you can't bring suit until you've paid the tax.
Well, let me say, there's a number of issues because, and first of all, let me back up because.
But I have one other thing I want you to bring up, and you could do that when you're
So
done.
I have to remember, you're not.
Okay, yeah, I'll bring it up, but address that, and my other thing is, has anybody brought up, any of the attorneys in the Supreme Court brought up the fact that there is funding for Obama's civilian army in the Health Care Act, and the fact that all the school loan programs have been taken out of private businesses and made government? Why are those two things in a Health Care Act?
No, those things were not brought up, and it's probably important to realize that the people went after these key provisions, including Medicaid expansion, without the permission of the states. That doesn't mean that there couldn't be lots of other lawsuits. There's so much going on in this law that there can be lots of other lawsuits that are brought to bear. But these were just considered the knockout blows. So there may be, there could be follow-up lawsuits if people have the funding and the guts and so forth. And that did not come up. Forgot. Paul Clement, let's see, and then NFIB were saying, they were both arguing that the lawyers arguing against it were arguing that even if it is a tax, they think that it violates the prohibition against a direct tax, and it doesn't come within the what is it, the 13th Amendment. So they were trying to argue even if it's a tax, then it's still not constitutional. That was a bold argument. I don't know if we'll go quite that far.